Good evening.
Good evening.
How are you?
I'm doing well. How are you?
I'm doing well. Doing
Good.
well. Happy Wednesday.
Happy Wednesday.
All right. Well, we'll go ahead and get started. All right. I'll go ahead and mute everyone. All right. Here we go. Ready? Snow, loss, lonesome February, promise, neither, satisfaction, excellent, average, awaiting, representative, outside, offered, pictures, district, pass, telegram, heavy, properly, entitled, none, superintendent, satisfied, samples, mistaking, intended, mistake, stating, field, length, informed, pudding, instance, wouldn't, keeping, forwarding, move, west, extremely, easy, truth, where, arrangements, perfectly, somewhat, looks, 50, minute, besides, figure, occasion, worse, selling itself, death, included, member, transportation. All right, let's do some phrases. Here we go. Just a moment. I didn't know. I don't know. That I know. That he knows. That you know. That he knows. What I know. What you know. When I know. When you know. Where you know. Whether he knows. Whether or not I know. Whether you know. Whether or not you know. Which he knows. Which you know. Ladies and gentlemen of the jury. About how large, too large, law officer, law enforcement officer, point of law, question of law, questions of law, where do you live, left-hand side, about how long, too long, no ma'am, yes ma'am, about how many, great many, how many, too many, marked for identification, matter of fact, may feel, may have been, may have had, may not, may recall, may recollect, may recollected, may remember, may remembered, may understand. All right. Oh,
Do you phrase know at KNOW at the end, like I know, he knows?
no, the only one I do is I don't know, like the final N, like YON for I don't know. Is that what you meant? Or I didn't know,
Well,
YIN, I can't know, YAN.
well, because I was just curious because you said what was coming up.
That I know?
Whether you know, whether or not you know,
Yeah.
like I know. I was just wondering if you do anything with no. I know, he knows, you know.
I don't do any of those. I just write,
Okay.
yeah.
Okay.
I just,
Okay. I just write them as well. I was just
yeah.
curious.
The only
Okay.
ones I do are all the I can't know, I don't know, I didn't know, I couldn't know. But yeah, all of these, like what he knows, that you know, like I would phrase what he and then come back for knows. That you,
Yeah.
I would phrase that you know what I mean?
Right. Okay.
Is that what you do? Whether or not I know, I would do whether or not, but then come back for I know.
Yeah, that was the one I was like, it made me think, I wonder if there's something for I know or you know.
Especially you know, because a lot of people talk like that. You know.
Yeah, I know that some people have talked about they have a brief for that, like when it comes up as like a junk interjection, just like, just because people say it so fast. I know some people have something.
Yeah.
Anyways, I was just curious because I don't phrase those, and I was just wondering.
Yeah, I guess you could do UN and flag it so it doesn't come up as you not, but
Mm-hmm.
for you know what I mean? Since we do final N for I don't know, I mean, you could and just flag it, especially because that does come up a lot. You know, I just,
You know?
I just said it. Yep. You know. All right. Here are some doublets. Here we go. Outboard motors, diamond setters, funeral parlor, metal stamping, offset printing, auto leasing, beauty school, wake up call, vacuum cleaner, tennis racket, decision making, motion picture, watch repairing, pizza parlor, laser surgery, stencil cutter, lighting fixture, shopping center, banquet room, parquet floor, wedding gown, drapery, fabrics, battery charger, landscape artist, electric heating, fluorescent lighting, insulation materials, limited edition, petroleum products, merchandising service, interior decorator, bleaching compound, astrological forecast, steamship terminal, television station, engineering report, louvered window, matching luggage, advertising agent, refrigeration unit, garbage disposal, factory maintenance, trash compactor, cash register, ceramic tile. All right. Now, here are some Disney movies with the year that they came out and how long they are. What the length is of each one. Here we go. Westward Ho, The Wagons, 1956, 90 minutes. Lady and the Tramp, 1955, 76 minutes. Davy Crockett, King of the Wild Frontier, 1955, 93 minutes. Littlest Outlaw, 1955, 73 minutes. 20,000 Leagues Under the Sea, 1954, 127 minutes. Peter Pan, 1953, 77 minutes. Sword and the Rose, 1953, 92 minutes. The Highland Rogue, Rob Roy, 1953, 91 minutes. Story of Robin Hood and His Merry Men, 1952, 84 minutes. Alice in Wonderland, 1951, 75 minutes. Cinderella, 1950, 74 minutes. Treasure Island, 1950, 96 minutes. Adventures of Mr. Toad, 1949, 68 minutes. Melody Time, 1948, 75 minutes. So Dear to My Heart, 1948, 82 minutes. Fun and Fancy Free, 1947, 73 minutes. Song of the South, 1946, 94 minutes. Make Mine Music, 1946, 74 minutes. Three Calibers, 1944, 69 minutes. Oh, it's Cabreros, not Calibers. Sorry about that. The Three Cabreros, 1944, 69 minutes. The Amigos, 1943, 75 minutes. Victory Through Air Power, 1944, 70 minutes. Bambi, 1942, 72 minutes. Dumbo, 1941, 64 minutes. The Reluctant Dragon, 1940, 74 minutes. Fantasia, 1939, 120 minutes. Pinocchio, 1940, 88 minutes. And Snow White and the Seven Dwarfs, 1937, 83 minutes. Pretty interesting. Huh. I like that one. All right. Let's do some final consonants. RK, RKZ, RJ, RJD. Here we go. He forged my name to the check. We went to the park on a lark. A diagram of the works was enlarged. We looked for a small spark. Your remarks are encouraging. They called that jerk Sarge. Non-voters were purged from the rolls. He was encouraged to continue. Their remarks caused sparks. The characters were forging ahead. We sang a dirge to the turkey. We urged Marge to continue. You can see it is a forgery. Don't shirk any duty. They were called the Young Turks. Sparks were seen in the parks. We urged the sharks to swim. You can't park in the parks. The blacksmith worked at the forge. We saw a large stork. All right. Let's do some names and addresses. Here we go. Let's see, hold on one second. Yeah, this is the one. Here we go. Paula C. Carlson, Carlson, West Ottawa High School Library, 1024 North 136th Avenue, Holland, Minnesota, 55104. Greg A. Schutt, Schutt, 221 Roosevelt Avenue, Bellevue, Kentucky, 41073. Isaac Newton Middle School, 4001 East Arapahoe Road, Littleton, Colorado, 80122. Patrick K. Frentrup, Frentrup, P.O. Box 413, Portage, Michigan, 49081. Francis J. Collar, Kollar, Counseling Career Development Center, Mansfield University, Mansfield, Pennsylvania, 16933. Rick Enyard, Enyard, the University of Tennessee at Martin, Tennessee, 38238. Rolanda G. Knoll, Knowl, 39 Parkin Drive, Spring Valley, Arizona. Donita F. Ellison, Ellison, P.O. Box 218, Casing, Oregon, 91730. Colleen M. Garcia, Garcia, 20 Sherwood Road, Englishtown, New Jersey, 07726. All right. Let's do some medical words. Here we go. Ischemia, leukocyte, swelling, posterior, diseased, obstetrician, gushing, intravenous, hydrotherapy, pressure, deceased, extremities, lateral, radiology, insomnia, clinical, orthodontics, angiogram, hemorrhage, laminectomy, dizziness, podiatrist, Alzheimer's, proctologist, umbilical, hepatitis, coccyx, epilepsy, hysterectomy, erythrocyte, endocardial, myopathy, retrograde, and hypodermic. All right. My last drill is going to be words that have final X as opposed to final K with the plural. So like tax versus tax. Okay, like the tax that you can step on versus pay your tax. Okay, here we go. Sex, section, fix, fiction, act, action, tax, tax, fax, faction, tracks, traction, dejection, conviction, prediction, eviction, lax, racks, sacks, affection, reaction. Here are your sentences. Put down the age and the sex. Abduction was limited. What is the attraction? They are hanging on racks. Follow his tracks. Please fix the car. He is in section 2. It was a sex case. The subtraction is wrong. Go on with the eviction. The prediction came true. Record his reaction. He has a good diction. What faction is it? Run for election. Whose axe was it? He's in a real fix. She called it seduction. I've stacks of work. Punish the infractions. The action was fair. The case is complex. Noise is a distraction. Use neck traction. It is pure fiction. She loves auctions. Friction causes heat. It lacks attraction. Use chicken backs. It's a strange reaction. Measure the adduction. Linen is made from flax. It is an infection. He built a triplex. Use a suction pump. Put down that axe. Watch your inflection. Please fix the sink. Use circumspection. Get 2 6-packs. The tracks need repair. The books are in stacks. Production is down. Use carpet tacks. All right. Let's do some literary. I marked this article. It's pretty good. It's called Fatal Distraction. All right. It says the story of one family's tragic loss to a distracted driver. It's about texting. I'll start at 180. No, yes, 180. And I'll work my way to 225, okay? All right. You know what, I stapled this, but I'm gonna pull it off so I can see it. All right, here we go. On a sunny morning in April 2011, Deanna Maurer was stopped in traffic on the 405 freeway in Orange County. Aside from the delay, life was good. At age 23, she had recently graduated from college and was helping to coach a high school girls softball team. She was also working for Whole Foods Market and had just finished an early shift before hitting the road for Los Angeles to take care of a friend's dogs. She never got there. A Toyota slammed into Deanna's Hyundai from behind. The impact of the crash was so severe that it broke her neck and severed 2 arteries. The cause of Deanna's death? Our daughter was killed by texting and driving, says her mother, Dawn Maurer. She now has a tattoo of her daughter's handprint on her left shoulder, so that she says, every morning, it's like Deanna has her arm around me. Every day, versions of the Maurer story play out across the U.S. Nearly 3,500 lives are lost every year to drivers who divert their attention from the road, even for a few seconds. Another 391,000 people are injured, according to the National Highway Traffic Safety Administration, NHTSA. As alarming as the body count may be, the number of potential perpetrators is exponentially higher. More than 2 in 5 drivers reported reading text messages or emails while driving in the past 30 days, and nearly 1 in 3 drivers admitted to typing text messages or emails while actually driving, according to the 2016 Traffic Safety Culture Index compiled by the AAA Foundation for Traffic Safety. Evidence would support those results. Just take a casual visual survey of drivers around you on any given day. Perhaps more sobering is the fact that many of us, if we were honest, have probably sent a text message when we knew we shouldn't have. In the Maurer family case, a stranger's decision to text had daily consequences. In the blink of an eye, Doreen Nicholas of San Diego, now 35, was convicted of felony vehicular manslaughter in Deanna's death. In the hour leading up to the crash, Nicholas had sent or received 14 messages and received 2 calls, according to her cell phone provider. She later said she was in a big hurry to meet her boyfriend for lunch. Court documents suggest she was also distracted, and so distracted that she hadn't realized traffic was at a standstill in front of her. The black box in her Toyota Prius revealed she was traveling 85 miles per hour at the moment of impact. There was no evidence that she had applied the brakes or turned the steering wheel before rear-ending Deanna's Hyundai, pushing it into the car in front of it and then the center divider. After the crash, another driver on the scene pulled Nicholas from the passenger side of her vehicle. Witnesses recounted Nicholas asking that driver to get her cell phone from her car and replying to questions with, "Where is my phone?" Nicholas eventually went to retrieve it herself and was talking on her phone when a CHP officer arrived. Nicholas's conviction took 4.5 years and 2 trials. The first trial ended with a hung jury, the second a 6-year jail sentence. During her sentencing, Nicholas did not admit to texting and driving, just that everything happened in the blink of an eye. She told the court in 2015, "Living day to day with the knowledge of what I did and the pain I caused is unbearable," she said. But 22 months after she was convicted, the decision was overturned because of an instructional error by the judge, and her punishment was reduced to 1 year in jail and 3 years of probation. Nicholas, a mother of a young girl, served 1,404 days, nearly 4 years, before her release. To avoid a third trial, Nicholas pleaded guilty to all of the charges. On the surface, Nicholas's reckless actions might be easily condemned, but her behavior is all too common. The 2016 Traffic Safety Culture Index revealed a majority of motorists say texting or talking on the phone while driving is an unacceptable safety hazard, yet a large proportion of those same people also admit to doing it within the previous 30 days, says Jake Nelson, AAA's Director of Traffic Safety Advocacy and Research. Distracted driving is probably underreported, Nelson adds, because most people will not admit that they were distracted at the time of the crash. A fatality complicates the problem. If the driver dies, you can't determine after the fact if somebody was distracted the way you can with somebody who was intoxicated, Nelson says. As a result, law enforcement has a hard time collecting accurate data about the role of distracted driving in traffic accidents. The multitasking myth, NHTSA, defines distracted driving as any activity that diverts attention from driving, including talking or texting on your phone, eating or drinking, talking to people in your vehicle, fiddling with the stereo or navigation system, anything that takes your attention away from the task of safe driving. Distractions can be sorted into 3 categories: visual tasks that require the driver to look away from the roadway to visually obtain information, manual tasks that require the driver to take a hand or hands off the steering wheel to manipulate an object or a device, and cognitive tasks that involve thinking about something other than driving. While visual and manual forms of distracted driving, like turning the radio dial, tend to bring higher degrees of risk, those risks tend to be shorter in duration, says AAA's Nelson. Mental distractions, like having a conversation, come with lower levels of risk, but they take much longer to complete, he says. So the net impact at the end of the day is that they rival one another for how risky they really are. People who text or operate the vehicle's air conditioning controls while driving may think they are multitasking. The reality is there's no such thing, Nelson says. You're switching back and forth between driving and doing other things. That's fine if you're sitting at your desk at work, but not in a car and driving 70 miles per hour down the road. There's a finite bandwidth with your brain, just as if there is with the computer or smartphone, he says. If you're trying to do many things or too many things at one time, everything moves more slowly. You're not processing things as quickly as you need to. All of these distractions, out of all of them, texting is the most dangerous, according to NHTSA. Sending or reading a text typically takes a person's eyes off the road for 5 seconds. at 55 miles per hour. That's like driving the length of a football field with your eyes closed. In addition, the AAA Foundation found that drivers may be mentally distracted for up to 27 seconds after sending a text message, even if they are using a hands-free system. That's why it's unsafe to send a text, even at a stoplight. Limits of the law. Distracted driving laws vary from state to state. Enforcement is challenging. The laws on the books usually don't prohibit distracted driving per se, but the behaviors it may cause, such as speeding, reckless driving, or unsafe lane changes. California has some of the nation's strictest laws. The state not only bans texting while driving, but also prohibits driving while using handheld cell phones. Whether or not a driver receives a ticket for these behaviors, for example, texting or using a handheld device, however, is ultimately up to the officer's discretion, says Kevin Teo, Public Information Officer for the California Highway Patrol. Fines vary based on the type and severity of the offense. In California, cell phone violations start at $20 for the first citation and $50 for each subsequent citation. For Deanna's parents, a ticket isn't enough of a deterrent. I would like to see something more like for drunk driving, says Don Maurer. After the second violation, if you kill somebody, you're in jail for murder. No text is worth a human life. In the aftermath of the deadly crash, the Maurers tried to raise awareness about the dangers of texting and driving with a billboard message on the 22 freeway in Garden Grove. It read, "Someone texting and driving killed our daughter. Your text can wait. In loving memory, Deanna Maurer." The Maurers could afford it for only a month. People would never believe you can cry every day for 6 years, but you can, says Dawn, who felt closure only after Nicholas admitted she was at fault. Dawn held her daughter's hand until the moment she was wheeled into the hospital elevator to have her organs and skin harvested. Deanna had enlisted as a donor just 1 month earlier. Today, Deanna's old bedroom in her mother's house is filled with photos and framed softball jerseys and greeting cards strangers had left at her grave. I don't think people understand the impact, Dawn says. Families break up. People never function the same way again. I keep waiting for Deanna to walk through the front door and say, "Hi, Mom." Deanna's father, Howard, refuses to own a cell phone. A decal in the back window of his Chevy Tahoe reads, "A person texting while driving killed my daughter. No text is worth a human life. In memory of Deanna D. Maurer, our sunshine." The decal has drawn a range of reactions. One driver gave me the finger, Howard recalls, but another driver pulled up next to me, honked, patted his heart, and threw his cell phone in the back seat. That was heartwarming. If we can change one life, it's worth it. Interesting. Oh, good. Olivia's with us. Hey, Olivia. I was pretty shocked when I read that somebody gave him the finger just because he has that on his window. I mean, good grief. I'd be the one that would throw my phone in the back, you know? Sheesh. All right, let's do some jury charge. All right. This is going to be legal opinion and argument. Okay, I'll start at 180 and work my way to 225. I won't spend very long in 180 since we're already warmed up. Here we go. Thank you very much, Your Honor. I'd like to first advise the court that what is at stake on this discovery motion is not simply categories of documents, some 60 questions involved in Penwell's deposition. I'd like the court to know that there are 5 depositions and 5 document productions or requests for document productions, which are pending at this time in this litigation, awaiting the outcome of the court's ruling on this particular motion, specifically the deposition of the president, Coast Federal, Mr. Blankley, Executive Vice President, Mr. Martin, and 3 other executives or officers, Van Zost, McNair, and Stempler. I submit to the court if Huntington Center is wrong about the relevancy of all of these collateral matters, which they inquired into of Mr. Penwell. I think all of this information is a colossal waste of money and time on themselves and on these other 5 Coast officers. Mr. Penwell's deposition consumed 4 days, 350 pages, which I hold in my hand are the product of the first 3 days. The 4th day, which was on April 1st, has not even been transcribed yet. So that this is the dimension of the kind of discovery which the court is being asked to permit here with respect to documents requested for the purpose of ascertaining the intent of Coast Federal at the time that the lease was entered into in 2003. First of all, Coast Federal was not even involved in the lease transaction. One of its predecessors, Southern Federal Savings and Loan, was. There could be documents still in Coast Federal's possession as a result of acquiring Southern Federal by merger. The problem here is that they never really tell us what particular intent they are after as far as the requested document production. The lease provisions that we are concerned with here are pretty standard boilerplate kind of provisions. First, there is a standard covenant against subleasing and assignment without the leasor's consent. That is Article 15. We have Article 34, which says the leasor, whenever its consent is required, shall not unreasonably withhold its consent. Now, what conceivable parole evidence, Your Honor, would be introduced to give some peculiar kind of interpretation to these provisions? As the court can see, there is a boilerplate printed lease produced and propounded by Huntington Center in 2005. I don't see what all of the documentation with respect to the negotiation of this lease is going to prove and how that is going to resolve specifically to the dispute, which is before the court, which is the validity of this sublease transaction. The issues are you have these two standard provisions, and what you do is you look at the conduct of the parties with respect to the requested subleasing. The fact is Coast Federal made the request in May. All right, what ensued thereafter with respect to assessments of the reliability and responsibility of the proposed subtenant and the conduct of both Coast and Huntington Center, which bear on the issue of waiver, estoppel, good faith. The point is, Your Honor, I don't believe that by any stretch of the imagination it is relevant to go back to 2005 when this lease was executed and started getting into everything that happened at that particular point in time. Now, with respect to the other requested discovery, both from the standpoint of documentation and 60 questions, which are the subject of this motion, the sole justification as I see it for all of this requested discovery is that Coast is the allegation Coast's conduct was motivated by particular anti-competitive desires, and that this somehow is relevant to the determination of this dispute, the validity of this sublease to Leo's Stereo. What Huntington Center is trying to do here, Your Honor, is to place an issue in question of what Coast's motivation precisely is and was when it asked Huntington Center for permission to consummate this sublease transaction. Specifically, they want to know what Coast's motivation was in moving out of the Huntington Center to relocate its branch office elsewhere in the center. And secondly, what its motivation was in wanting to sublease this property to Leo Stereo, which admittedly is a non-savings and loan association subtenant. Coast submits that this issue of motivation is really not an issue and cannot be an issue in this case. It is a false issue. It is a non-issue in all of the following respects. First, Your Honor, with respect to the concept of a business moving from location A to location B in order to improve its business, that to me inherently by definition is not anti-competitive. It is competitive. The business is trying to improve itself, trying to bring in more money, trying to compete better with its direct competitors in the area. There is nothing wrong and illegal about that. I can't see anything wrongful and illegal about a business, any business, not just the savings and loan business, wanting to move to a better location. What conceivably is anti-competitive about that? Secondly, let's assume for the purpose of argument that a business in location, say 91 Huntington Center, with the right under the lease provisions to sublet with the landlord's agreement not to unreasonably withhold consent, is motivated after it moves out to a better location, not to sublet to one of its direct competitors. I submit again, Your Honor, there is nothing wrongful here. There is nothing illegal about the motivation, whether that is an only motivation or whether that is just a part of their motivation. I mean, if you look at it in another context, Your Honor, I submit it is absurd. Let's assume that McDonald's was at Huntington Center as a leaseor. They wanted to move across the street to Edinger Plaza because there is a freestanding facility. The traffic is better. They had better visibility. So they move across the street and they want to sublet Huntington Center. Is it wrong for them not to want to sublet to Jack in the Box? We would like to sublet to another responsible, reliable, financially credible subtenant, which would be reasonably acceptable to the landlord. We didn't want to put a direct competitor across the street from us. Secondly, Your Honor, motive is irrelevant in the context of this kind of contract dispute. After all, this is a contract dispute. It has to do with the interpretation of a lease contract. I submit to Your Honor, if Coast is in violation of their master lease with Huntington Center in either moving out of the Huntington Center or in subletting to Leo Stereo, the fact that Coast was motivated by the most pure and pristine kind of belief, what it was doing was right. The court is going to say, it's tough. You may have thought you were in violation of an agreement. You may have thought you were not in violation of the lease. You forfeited the lease. We evict the subtenant from the premises. Conversely, it seems to me if Coast had a legal right to do both of these things, what its motive might have been in exercising that legal right is legally irrelevant. I think that is the lesson of many, many cases in California. The point being, if the contracting party has a legal right to do or not to do something, the motive which induced is to exercise that right and is legally irrelevant. One case, as an aside to the court, Monahan versus Department of Water and Power, 48, Cal. 3rd, 2nd, 754. There was an allegation that a particular employee, because of whim, caprice, and malice, the court said it is nothing but an allegation of motive. The standards of the law are external. Motives are not actionable. In other words, it isn't whether or not Coast was acting within its legal rights in effecting this sublease. It is not going to be determined by what went on in its mind, but how it internalized the whole thing. It's going to be determined by the external conduct of the parties. That is, what either of the parties did or did not do in relation to their legal rights under the master lease. The court goes on to say here, well, there is a legal right to do a certain act. The motive which induces the exercise of the right is of no importance. Thirdly, Your Honor, again, there is the Huntington Center seeking to assert anti-competitive motives on the part of Coast. As I pointed out in our points and authorities, Huntington Center is not a savings and loan association. In other words, they really have no standing to complain of this. Gibson Savings and Loan Association is in this case. It has filed a cross complaint against Coast. The whole point of their so-called anti-competitive motive that Mr. Adler said a few minutes ago was allegedly Coast seeking to either exclude or prevent savings and loan competition at the Huntington Center. I might point out that Huntington Center is a huge shopping center. Huntington Center is just one of the many, many locations and spaces within that center. Okay, so we'll stop there. There's more. We'll finish it on Friday. All right. Go ahead and start some Q&A. Okay. And it's going to start out with the court. Okay. We'll start out at 180. There we go. Does that figure include the $16,098.80 on Schedule C? Yes, sir, it does. Well, then is $59,669.44 the total loss? Yes, sir. Okay, rather than the $75,000 plus as alleged in your cross complaint? Yes, sir. I have nothing further at this time, Your Honor. Very well, counsel. Thank you. Mr. DeSalvo, I am referring now to a document entitled Answers to Interrogatories dated August 15, 2013. This was the loss as originally computed, I believe. Is that correct? Yes, ma'am. I figured that in Darien, Connecticut in about September of 2012, and I figured it from the best available records that I had at the time. And although this document was apparently verified by Mr. Chamberlain, it was from information that you had furnished to him. Is that correct? Yes, ma'am. Now, obviously, there are some changes on it because the figure now, rather than $75,000 plus, it says $59,000 plus. Is that correct? Yes. Now you correct me as we go along here if I am wrong. As I understand your testimony, the $6,411.13 is still a correct figure? Yes, it is. How about the $14,353.20? Is that still a correct figure? I don't know. I have got $13,353.20, and the last five digits are 6 of the 7 digits are the same. I don't know whether this is a 13 or a 14. It's essentially the same. Can I look at something else here? Yes, something in here. In here, I would say that either I made a mathematical error in that, or there is a mathematical error here, but the total number of mirrors claimed hasn't changed. If you were to take a minute, could you figure out whether this $13,353 is correct or the $14,353 is correct? I will say the $13,353 is correct because I see it's been corrected on here. Okay, so with respect to the loss from mirrors cut, there has been no change between August 15, 2013 and your testimony today in the figure of $6,411.13. That's right, yes ma'am. And the only change in the next item, loss from mirrors sold at 20 cents a foot, is $1,000, which apparently was a mathematical error originally. Is that a correct statement? Yes, ma'am. Now then, do you have an extra copy of what you are referring to? Yes, I am looking at the summary of loss. Now the next figure, loss from sale of reject vanity mirrors on this schedule that you have just handed me entitled Summary of Loss, shows $26,098.80. On the answers to interrogatories on August 15, 2013, it says loss from sale of decorator mirrors. In other words, it doesn't mention vanity mirrors in that one, but are we talking about the same loss there? No, there has been a change in that. Well, I mean the same type of loss. Same type of loss, yes ma'am. What is the change that accounts for the increase from $20,593.68 to $26,098.80? Can you explain that increase? Yes, when we left here on Wednesday with instructions to get some viable figures together, we went back to the Hartford office and we were able to determine from more complete records that there were, in fact, surprisingly enough, all of the vanity mirrors that had been sold. They had been, yes ma'am. And they had not been sold on August 15, 2013. No ma'am, I don't think they had been. I didn't have the complete records when I was back in Darien. When these interrogatories came in for answer in August of 2013, were they sent back to Connecticut for you to answer them? I never saw them before. Well, you must have from what you have just said. You prepared this and sent it back to Mr. Chamberlain, did you not? I prepared this document in September of 2013. I am sorry, counsel. What are we referring to? Counsel, we need a clarification. I am referring to Exhibit A attached to the answers to interrogatories with a mailing affidavit of August 15, 2013. That was in answer to interrogatory number 18, set forth in exact detail the computation of damages in the amount of $75,583.26 as alleged on page 5, line 1 of your first amended complaint. Thank you, counsel. All right, let's switch transcripts. So I got to 200 on that one. So this one will start at 200 and work our way to 225. Okay. All right. Here we go. And plaintiff starts with this one. Here we go. Showing you a letter, Mrs. Carter, dated April 21, 2013. Do you recognize the signatures on the bottom of the letter? Yes, I do. And whose signatures are those? My mother, Sarah Bailey, and my father, James Bailey. Okay, now, Your Honor, may counsel stipulate that the letter which I have shown to the witness is identical to the letter marked C. A stipulation, counsel, that this copy is the same as the copy that you have identified? Yes, I have no objection, Your Honor. All right. Mrs. Carter, do you recall purchasing a condominium in Virginia Beach on or about April 13? Yes, sir. And did you receive monies from your mother and father towards the purchase price of the condominium? Yes, I did. Did you have an agreement with either your mother or your father to the effect that they would acquire an interest in ownership in the condominium? Objection, Your Honor. Move to strike. Motion granted. At the time that the money was given to you to acquire the condominium, did you have conversations with your mother and father? Yes, we did. And would you please tell us what those conversations were? Your Honor, I would only ask counsel before the witness gets into this to please identify the place, time, etc. of these conversations. Sure. What was the first conversation you had with Sarah and James Bailey? Do you mean about purchasing or after we purchased the condominium? I'm sorry, I'm not clear on your question. Prior to the purchase. Prior to the purchase, I believe it was sometime in the winter. They had seen it. Winter of what year? 2013. They decided to move to Virginia and retire near me. And did they have any conversation following that one? Then they came to Virginia for a visit. I believe it was January or February of 2013. And at that time, we talked about their move to Virginia. Did you have any conversations with Sarah or James Bailey concerning where they would live? Yes, we did. And did any of those conversations concern the condominium in Virginia Beach? Yes, it did. And can you tell us in terms of which came first in time when the first conversation occurred? My husband knew we wanted to purchase that condominium. Mrs. Carter, please respond to the question that he's asking you. When did that first conversation occur? I believe it was February of 2013. And did you have a conversation with either James or Sarah Bailey concerning the purchase price of the condominium? Yes. Will you recite to us the substance of that conversation? Yes. In February of 2013, we discussed the matter. It would have been in my home that we would have discussed it. We had seen the condominium and my husband and I wanted to purchase it. Tell us approximately what was discussed. Well, I would have said to them that we needed a certain dollar amount to purchase it. They said yes, they wanted to live there. I said, would they give us the money? Did you have any further conversations with either James or Sarah Bailey concerning the dollar amount of the condominium? Not after that, no. And in that conversation that you have with James and Sarah Bailey, did either of them tell you that by giving you the money, they would be acquiring an interest in the property? Objection. Leading the witness, Your Honor, move to strike. Overruled. Please answer the question. No, they did not have an interest in that condominium. They never had an interest in the condominium. No, that wasn't the question, ma'am. Ask me the question again, please. I'm sorry. I don't understand the question. Would you rephrase the question? It was rather a leading question, which I allowed her to answer. Can you remember any of the terms or substance of that conversation? No, that was it. We said how much we needed and they said yes, okay. And that was the conversation. Were you aware that they sold their home in Lansing, Michigan? No, I was not aware of that at that point. Did you subsequently become aware of that? Yes, we did. And did James or Sarah tell you anything with respect to what or where they intended to live out the rest of their lives? Your Honor, objection leading. Sustained. Mrs. Carter, you were present in court during the testimony of James and Sarah Bailey? Yes, I was. Did you at this time in the summer of 2013 talk with your father, James Bailey? Yes, I did. Concerning the condominium? Not concerning the condominium. Did you ever tell James Bailey that the condominium would be divided between yourself and Sarah Bailey? No, I did not. Do you recall James Bailey testifying that there were two conversations which occurred in the summer of 2013? Yes, I recall him saying that. Did you ever have either of those conversations with James Bailey as he recited them to the court? No, I did not. All right. How are we doing on time? Good. All right, let's go ahead and switch transcripts again. Do a little bit more. Now this one I'm going to go right to 225. Okay. All right. Defense is questioning, and then it's going back to plaintiff, I think. Let's see. Well, there's going to be some colloquy. It'll be good practice. So we'll do this at 225. Here we go. If you are doing an investigation, would you wad that paper up? I personally know I wouldn't. I would put it in my notebook with my notes that I did on this date. And if somebody questioned me later on about it and said, I don't think you really did it, I can go ahead and get it. Here it is. You can pull it out and say, here's mine. Would it be the same if you contacted the CII or FBI, all of those various agencies? If they don't give you a piece of paper, at the very least, you get the name of the person that you talked to that gave you the information. Thank you, Your Honor. Nothing further. Thank you very much. Nothing further, Your Honor. Mr. Lonsford, thank you very much for coming. You're free to leave, subject to possible recall by either side. Thank you very much. Mr. Bristol, any other witnesses? No, I wasn't sure. I wasn't sure how to schedule today, so I scheduled Mr. Lonsford, but we will be ready to go. We'll recess then. Please do not discuss the case with anyone. Do not form an opinion until the case is submitted to you. We'll be in recess until 10 tomorrow morning. Have a nice evening. We are here in open court out of the presence of the jury. Present are Mr. Abackerley, Mr. Bristol, and Mr. Myers. Shall we go through the exhibits at this time? Fine. We can do that, Your Honor. Your Honor, can I have just a moment with Mr. Lonsford, please? Sure, go ahead. I believe my clerk has provided each of you copies of the exhibit list. Mr. Abackerley, what exhibit would you like to move into evidence? Could we go off the record for just a minute? Certainly, off the record, back on the record. This is the matter of people of the state of California versus William Myers here in open court. Present are Mr. Abackerley, Mr. Bristol, and Mr. Myers. Mr. Abackerley, with respect to any exhibits that you'd like to move into evidence, I would like to first address exhibit number 53. That is an exhibit that is primarily being introduced in a bifurcated proceeding with regard to proving up the defendant's prior state prison commitment. However, I am offering that in the guilt phase of these proceedings at this time as corroborative evidence of one of the defendant's statements that relate to the time that he was in prison with one of the victims. Do you know, was he in prison with Mr. Michael Williams on the San Diego case? He was in prison on the San Diego case. Michael Williams was in prison on another case. Was it the same period of time? Yes, it was. Okay, then very well. Mr. Bristol, what is your position? Well, my position is there was an agreement at the beginning of the case. We were bifurcating the issue of the priors from the guilt phase. And now to do a switch affects my case. I would have treated the case and witnesses and gone totally different in a different direction if we had been approached with the understanding that this was coming in as part of his guilt phase or at this phase of the trial. And now I am not. I'm not in the position to go back and cross-examine certain witnesses about that. Lloyd Grant, for instance, I could probably put in Mr. Gonzalez, put him back on the stand. I'm objecting to it, though. All right, Mr. Abackerley, any response? I'll submit, Your Honor. Other than the court has, if the court allows 53 into evidence, then it undermines the very purpose of the bifurcation. The fact of the prior prison term was bifurcated from the issue of guilt or innocence primarily to minimize any prejudicial effects that the information of a prior prison term would have on the jury, how that might affect their verdict. Court understands that there is some probative value from the prosecution's point of view and that it would be some corroboration of Mr. Myers' statements to law enforcement back in Ohio. However, that is the kind of information which a person would not normally make up. It's the kind of information that I think in an ordinary course of human activity, someone does not indicate that they were in prison with someone else if in fact that is not true. So in any event, in the absence of any evidence by the defense suggesting that it was not true, the court's inclined to not allow it, or to allow it maybe, but under the evidence code section 352, no, not allow it. The court, having balanced and weighed any prejudicial value against any probative value, finds specifically that the probative value is outweighed by the prejudicial value, and the court does sustain the defense objection, and 53 is not admitted at this time. And we'll just have to wait and see if it is appropriate then, and may be admitted in the bifurcated phase of the trial. Your Honor, Mr. Bristol has just brought to my attention something that has escaped my mind. Exhibit 53 was actually placed in evidence at the time of the preliminary hearing in this matter. I am not in possession of copies of the document, neither is Mr. Bristol. I had indicated to him that I would not provide copies of those documents to him, which I did not do. So I'd request if the court would indulge the people to have the clerk make copies of those documents and provide them to Mr. Bristol. And do you have any objection? And I have no objection to the court releasing the exhibits to Mr. Abackerley for the purpose of allowing him to make those copies if he would like. Okay, well, what we could do that was admitted into evidence at the preliminary hearing, is that correct? Yes, Your Honor. Yes, Your Honor. Would both of you agree and stipulate that the exhibits may be returned to the people? I have no objection, Your Honor. Is that acceptable, Mr. Abackerley? That is, Your Honor, except that it has also been submitted for identification at this time. It's identified in this case, so we can't do that. We'll make copies for the prosecution and for the defense, okay? Thank you, Your Honor. Thank you. Certainly. With regard to exhibits 27 and 28, 27 being the diagram drawn by Detective Gonzalez and 28 being the diagram of the crime scene that the defendant drew, I'd be moving those into evidence at this time. I think 27 was a joint effort by Mr. Myers and Detective Gonzalez, and 28 was Detective Gonzalez by himself, I thought. That's correct, Your Honor. All right, and Mr. Bristol, any objection? Submit. Okay, 27 and 28 are admitted into evidence. Exhibit 30, that is the shoes of the defendant, is moved into evidence at this time, or I am requesting it. Okay, any objection? Well, the shoes of the defendant, I don't know of any shoes of the defendant. I know of some of the shoes that were found in a hotel in Cincinnati. Those are the shoes that he is referring to. Okay, I submit it. Okay, Exhibit 30 is admitted into evidence. The actual tapes that were played are 32A, 33, 34A, and 35A, and I'd be requesting that those be admitted into evidence at this time. Is that 32, 33, 34? What was that again? 32A, 33, 34A, and 35A. You're moving those into evidence? Yes, Your Honor. Any objection? Submit it. All right, 32A is admitted into evidence. 33 is admitted into evidence. 34A is admitted into evidence. 35A is admitted into evidence. Any other? Yes, Your Honor. Exhibits? I believe, at least according to what I have here, that the remainder of the exhibits up to number 86 have been previously admitted into evidence. 32 is not admitted. 34 is not admitted. 35 is not admitted. 37, 38, 39, not admitted. Those are just transcripts. 40 is a one-page form dated August 22nd, 2012. Okay, and that is the polygraph. That is not admitted either. 41 is the pre-polygraph tape. That is not admitted. 42 is the polygraph exam itself. That is not admitted. Then I believe we will go all the way up to, then the next one is 86. That is not admitted. Okay, so we'll do some read back. Okay. So the first time I do this, I'll do it at 225, then 200, then 180. That was a lot of 225 practice there. All right, here we go. Plaintiff is questioning. Ready? You didn't know about that other person before you went out there, did you? No, I didn't. You had no time to check on that other person, had you? I was informed based on the report that it was Rodney. When you went back to the office, was not the purpose of returning to your office to investigate Miss Pearson immediately? Yes, that was the only purpose. No, it was to discuss the results of the investigation with my supervisor and to verify the information that she had given me about herself and about Mr. Rodney. Did you make out a report of the incident on your way back to the office? What incident? Of your first meeting with Miss Pearson? Not at that time, no, sir. When did you make that report out? I think that my first report is dated on the 16th of April, which covers the initial interview and subsequent interviews. I thought you said something about the fact that you had immediately recorded the conversation that you had had so that you would have an accurate record. I took notes during my interview with Miss Pearson, yes, but as far as a report, no. At what time during the first visit did your suspicion focus directly on Miss Pearson? Well, it focused on her for the first time when she admitted that it was she and not Rodney that had actually forged the check. She told you that. Yes, she did. I was surprised. Up to that time, based on the telephone conversation with Lieutenant Johnson, I was led to believe that it was in fact Rodney who had forged the check. But she admitted that she had done it. That is what she informed me. Does it happen often that your suspicions change drastically? No, actually, it is rather unusual, sir. Well, your suspicions were considerably different from what they had been. Oh, sure. After she admitted forging the check, my thinking certainly changed. How much weight do you give it to a person's manner when he tells you something? Actually, I give it quite a lot of weight. Okay, so let's do it again. 200 this time. Ready? You didn't know about that other person before you went out there, did you? No, I didn't. You had no time to check on that other person, had you? I was informed based on the report that it was Rodney. When you went back to the office, was not the purpose of returning to your office to investigate Miss Pearson immediately? Yes, that was the only purpose. No, it was to discuss the results of the investigation with my supervisor and to verify the information that she had given me about herself and about Mr. Rodney. Did you make out a report of the incident on your way back to the office? What incident? Of your first meeting with Miss Pearson? Not at that time, no, sir. When did you make that report out? I think that my first report is dated on the 16th of April, which covers the initial interview and subsequent interviews. I thought you said something about the fact that you had immediately recorded the conversation that you had had so that you would have an accurate record. I took notes during my interview with Miss Pearson, yes, but as far as a report, no. At what time during the first visit did your suspicion focus directly on Miss Pearson? Well, it focused on her for the first time when she admitted that it was she and not Rodney that had actually forged the check. She told you that. Yes, she did. I was surprised. Up to that time, based on the telephone conversation with Lieutenant Johnson, I was led to believe that it was in fact Rodney who had forged the check. But she admitted that she had done it. That is what she informed me. Does it happen often that your suspicions change drastically? No, actually, it is rather unusual, sir. Well, your suspicions were considerably different from what they had been. Oh, sure. After she admitted forging the check, my thinking certainly changed. How much weight do you give to a person's manner when he tells you something? Actually, I give it quite a lot of weight. All right. One last time at 180. Here we go. You didn't know about that other person before you went out there, did you? No, I didn't. You had no time to check on that other person, had you? I was informed based on the report that it was Rodney. When you went back to the office, was not the purpose of returning to your office to investigate Miss Pearson immediately? Yes, that was the only purpose. No, it was to discuss the results of the investigation with my supervisor and to verify the information that she had given me about herself and about Mr. Rodney. Did you make out a report of the incident on your way back to the office? What incident? Of your first meeting with Miss Pearson? Not at that time, no, sir. When did you make that report out? I think that my first report is dated on the 16th of April, which covers the initial interview and subsequent interviews. I thought you said something about the fact that you had immediately recorded the conversation that you had had so that you would have an accurate record. I took notes during my interview with Miss Pearson, yes, but as far as a report, no. At what time during the first visit did your suspicion focus directly on Miss Pearson? Well, it focused on her for the first time when she admitted that it was she and not Rodney that had actually forged the check. She told you that? Yes, she did. I was surprised. Up to that time, based on the telephone conversation with Lieutenant Johnson, I was led to believe that it was, in fact, Rodney who had forged the check. But she admitted that she had done it. That is what she informed me. Does it happen often that your suspicions change drastically? No, actually, it is rather unusual, sir. Well, your suspicions were considerably different from what they had been. Oh, sure, after she admitted forging the check, my thinking certainly changed. How much weight do you give to a person's manner when he tells you something? Actually, I give it quite a lot of weight. Okay. All right. Let me know when you find it.
Okay.
Found it? All right. So if you want, I'll take the first one.
Okay.
All right, here we go. Question. You didn't know about that other person before you went out there, did you? Answer, no, I didn't.
Question. You had no time to check on that other person, had you? Answer, I was informed based on the based on, I don't know. Based on the
Do you have RORT?
oh, no.
No.
Based on the report
Yeah.
that was Rodney.
Very good. Question. When you went back to the office, was not the purpose of returning to your office to investigate Miss Pearson immediately? Answer, yes.
Question. I have it all messed up.
It's okay.
Something that was the only purpose.
Yep.
Answer, no. It was to discuss the results of the investigation with my supervisor and to verify the information that she had given me about herself and about Mr. Rodney.
Perfect. Question. Did you make out a report of the incident on your way back to the office? Answer, what incident?
Question. I have of your, I don't.
That's right. Of.
Oh, okay. Of your first meeting with Miss Pearson. Answer, not at that time. No, sir.
Perfect. Question, when did you make that report out? Answer, I think that my first report is dated on the 16th of April, which covers the initial interview and subsequent interviews.
Question, I thought you said something about the fact that you had met
Do you have immediately?
immediately. No, well, immediately recorded the conversation that you had so that you would have an accurate record. Answer, I took notes during my interview with Miss Pearson, yes, but as far as a report, no.
Awesome. Question, at what time during the first visit did your suspicion focus directly on Miss Pearson? Answer, well, it focused on her for the first time when she admitted that it was she and not Rodney that had actually forged the check.
Question, I'm sorry.
It's okay.
She said you that.
Okay, close. She told you that?
I figured it was she told you about that. That's weird that I wrote she said you that. That's weird. Okay. Answer, yes, she did. It was surprising up to that
Do you have I was surprised?
Oh, no, I have it was.
It's okay. No worries.
I was surprised up to that time based on telephone conversation with Lieutenant Johnson. He was led to believe that it was in fact Rodney who had forged the check.
Okay, so the only thing is instead of he was, it's I was.
Okay.
So then okay, then you just practice on I was, because that was two of them. So that's good.
Mm-hmm. Okay.
All right. Okay, question. But she admitted that she had done it. Answer, that is what she informed me.
Question. Does it happen often that your suspicion changes drastically? Answer, no. Actually, it is rather unusual. Uh, I don't know. I have sure. I don't know why.
It's sir.
Oh, sir. Okay.
So you're so close. Like you just threw in an H.
And I didn't have the time, I guess, to get the comma in there. So I'm just like, what?
Oh, don't worry about it. Question. Well, your suspicions were considerably different from what they had been. Answer. Oh, sure. After she admitted forging the check, my thinking certainly changed.
Question. How much weight do you give to a person's manner when he tells you something? Answer. Actually, I give it quite a lot of weight.
Awesome job. See, and it's never as bad as you think, You think, oh, I can't read it. So you think it's sure, but it's sir. So it's really not that far off,
Yeah, but I sit here and I think, would I have figured that out if it was a test situation? I don't know, because I don't even write sir even close to how I write sure, really. So that's weird.
But that's okay because it does it shows you what you're doing.
Yeah.
The more you read that.
Sometimes it's just like a puzzle to me. Like, why
Oh,
did
I
I
know.
do that? And sometimes I just can't figure out why I did it that way as hard as I try. A lot of times you can kind of go, oh, okay, I see what my fingers did there, but I don't know. Maybe I heard sure that I
Yeah,
don't know.
maybe you did instead of sir.
I
That's
don't
true.
know.
Especially that you did the SH long UR.
I did. Yeah.
Yeah.
Anyways,
Well, you have a great night.
you too. Thank you.
Thank you. And I'll see you Friday, hopefully.
Yes, I will be here on
Okay.
Friday.
Sounds great.
I'll see you then.
All right. Thank you.
Thanks. Bye.
Bye.